Now back to the show. This is The Law Show on CL 650.
Freedom is just another word for nothing left to lose. Nothing. That's all that Bobby left me.
Welcome back to The Law Show here on CIL 650. Mark Perry and Jessica England from Westside Family Law in the studio with us. And we've been talking about guardianship and custody, parenting time and access issues. Talked a little bit in our last segment about child support and how the dollars get arranged and shared and those sorts of things. I wanted about, and Jessica, you've done a splendid job of reminding us how the system, including the new Family Law Act of a couple of years ago here in BC, really has changed a great deal in recent times to, at all times, assure us, all of us, that the children's interests are first and foremost. At what point do the courts or mediators like Mark, at what point in the process do children actually get heard from, if at all?
Well, this is this is an interesting topic as well, because it is new legislation, and it's different in that it tells us that we are actually obligated under the Family Law Act to consider the children's views if appropriate.
Okay.
So whereas before, I would say that generally speaking, you would consider the views of children maybe, and only if they were around the age of maybe 12, 13 years old, so a bit older. That's changed significantly now. So we're looking at considering the views of children who are significantly younger. So in some of my cases, they have been 8, 9, 10, 11 years old, quite a bit younger. And the other interesting issue is how that's going to be affected. As you say, how do you bring them into this process?
Sure, yeah.
So, and that hasn't really been settled now. So do they write affidavits, legal documents? Do they appear in court to give their views? I think that everyone would agree that neither of those is a great way to incorporate their views. More often we get something called a Section 211 report, or a views of the child report, where they're able to sit down in a more comfortable environment with a trained professional, a child psychologist, who will canvass their views in a neutral way. The other way that their views have been incorporated, which is a bit exceptional, but I think that the law is maybe moving towards this, is to have them attend judges' chambers. So in the back room, if you will, not in open court, to sit down with a judge and have a talk about how they feel about the situation and different arrangements. But that, I think, has more to do with the comfort level of the judge in talking with the children directly. So there isn't one prescribed way of doing this yet. We're still working it out.
But we are working in terms, or in favor of the inclusion, Mark, of more children, and certainly their viewpoints, than we ever have before.
Absolutely. Absolutely. And again, this is a trend, certainly enhanced and made more clear by the new legislation, but it's a trend that's been happening for a long, long time.
Right.
But Jessica, in one of her cases recently had the children interviewed by the judge. That was a few months ago.
That's
and
right.
I've forgotten the ages of the two children in that case.
One was 7 and the other one was 9.
Okay.
And it was interesting, they actually went in together so that they have that mutual support.
Sure.
They're very close in age.
Okay.
And then also went and once they became a little bit more comfortable, spoke with the judge separately as well. And I think that achieved a very good outcome in that case, in that the children were very comfortable with what ended up happening. And I think it's important to note, though, that when the child gives their view or their preference, this isn't the be-all and the end-all. This doesn't mean that the judge is bound to it, or that this is what they're going to do, or is even the best thing for them. It's just one consideration in a number of factors to be considered by the court.
But a consideration that, Mark, up until quite recent times, was never a part of the decision-making process, was it?
No, I wouldn't go that far.
Okay.
But I think it's enhanced. And really it's important, I think, to appreciate why it's why it was frowned upon or less important previously.
Right.
And that was because of concern that one parent might influence the children.
Right.
So, I often hear from clients in my office when we're talking about a views of the child report that they think, the other parent's going to feed the kids chocolate on and and let them stay up watching, the same late night shows that you're watching.
Terrible law shows that I'm so notorious at watching. Yes.
So when they meet with a psychologist or meet with a judge, they're going to say, I want to live with him or her.
Right, sure, of course.
I
get to stay up late and watch TV.
That's right.
Right.
So that was the concern.
Okay.
And of course, part of the use of judges now is to train judges to ask questions to elicit really what the child's views are, not simply what maybe a parent might have told the child.
Right.
And the psychologists who have been doing this for a long, long time are very careful in their questioning of children to really get at what are their views.
And I think this would also surprise a lot of people, Jessica, is the number of professionals in the system, in the family law system, who are dedicated exclusively to working in the family law system and representing children and their interests. Parenting counselors, child counselors, psychologists, all sorts of support workers. It's quite intricate, isn't it?
Absolutely it is, and getting more so every day.
Is it getting cluttered, or is it still working?
I think now we have parenting coordinators available to us, as well as to some extent arbitrators, and that's so new. A lot of lawyers, we haven't really seen the full extent of their involvement yet.
Sure,
I'll put it that way. We're still working it out.
It's a work in progress.
It's a work in progress.
Right.
Yes.
But it's a positive thing because there are different skill sets. There are different situations.
Right.
And so in one case, it might well involve a parenting coordinator. In another case, you really need a psychologist interviewing a child to get information of what the child's views are.
Right. When back to if you don't mind for a minute, back to the matter of the dissolution of property. When this comes down, push comes to shove, and everybody has to declare, I would assume, all of your assets and all of that. Does it from time to time occur where people, well, shall we say, don't completely fill out the forms in their entirety?
They forget?
Forget. They're in quotes. Yes. We're gaming the system, I think, a little. Mark, do
Yes.
people still try and do that?
Absolutely.
Right.
Absolutely. And again, that might be another instance where mediation is not the proper route, or collaborative family law is not the proper route.
Right.
Because litigation involving a judge scrutinizing these sworn statements
and
as
perjury charges.
Absolutely.
Right.
Yeah. And hearing a party being cross-examined by someone like myself or Jessica on the stand as to what the assets they have, comparing what they've said to their bank account statements and various other documents, that's why litigation will always be a part of the answer to family law cases.
Right.
Some people aren't truthful.
That's right, and you also have access to discovery procedures that you don't in mediation. You can get orders for disclosure and that type of thing as well.
Interesting. We have only 1 minute left, I say with regret. How soon into the process, when you are in a relationship and it's over and you know it and the clock is ticking and something's going to blow up here if I don't get something done, at what point do you call a lawyer, Jessica? How early in the process? The earlier the better?
Absolutely. I say as soon as you can get to see us, we'll give you valuable advice about your options and perhaps also what you should and should not do, as well as some peace of mind, what it might look like for you moving forward.
I would think peace of mind would be the key, wouldn't
Absolutely.
it, Mark? Just, your life is just somebody hit the trap door button and it's just opened up underneath you and you don't know, but you're falling and it's not going to end well.
Absolutely.
So a lawyer can at least give you a clue about what things might look like over the next while.
Right. I find, Sterling, actually, just the information, whether it's positive or negative, or, that's for somebody else perhaps to determine, is useful. And people are thankful just to know, because, again, I think it's part of being in that emotionally fragile state. You fear the worst. I'm going to be out in the street.
Oh,
I'm
sure.
not going to have anything.
Yeah.
And we're part of our advice is that's not going to happen.
Absolutely. Westside Family Law, our guests, Mark Perry and Jessica England, all of their contact information is available on the website, which is westsidefamilylaw.ca. The phone numbers, the address, there's even a map, for crying out loud. And give them a call. And, if it may not be happening to you, but, it's always happening to someone we know. It just is. That's life. Thank you both for coming. It's wonderful to see you, Jessica, on your first occasion. Here's hoping there will be many more.
Thank you so much, Sterling.
Good to see you again, Mark.
Nice to see you too, Sterling.
See you next time.
All right.
And that's it for this episode of The Law Show.